I assume this is coming through loud and clear. Good evening, everyone. Konbanwa. Walkers Horitsu Jumusho no Tomu Granger to moshimasu. Thank you for attending tonight's seminar. The topic of the presentation tonight that we will be giving is Cayman Islands fund structures. We will be giving this in the context of what a Japan-based asset manager needs to do in terms of operating a Cayman investment fund structure. My name is Tom Granger. I am an investment funds partner based in the Hong Kong office of Walkers. I'm joined tonight by Tim Stevens, who is one of my fellow partners based in the Singapore office of Walkers, who is also a fund specialist. As I said, tonight's presentation will be Cayman investment fund structures. We will spend approximately 50 minutes covering a fairly broad range of topics. This is a huge area, and so there's a lot to get through in 50 minutes, but we will try and give a very high-level overview of the key considerations that an asset management business in Tokyo should be aware of when looking to fundraise using a Cayman fund structure. As an outline for this evening's presentation, as I said, it's a very large area, so we'll try and get through it in 6 main areas. The first is to give a brief overview about Walkers. Then we'll touch upon why a Japan-based asset management business would structure using an alternative investment fund in the Cayman Islands. We will run through an overview of the structure types and key differences within those particular structures. Then we will look at the 2 main structures that we see being used and utilized by Japan-based asset managers. The first being the unit trust, which is our tried and tested structure, and the second being an exempted limited partnership, which is our classic structure that we regularly see in Japan. And finally, we will look at the Cayman regulatory regime as far as it applies to these types of structures and what asset managers in Japan really need to be focusing on as far as setting up one of these structures. Very quickly, as far as Walkers is concerned, we are a boutique offshore law firm. We specialize in financial services, but as far as Tim and I are concerned, we specialize in setting up investment fund structures. Our head office is in the Cayman Islands. We have over 1,000 staff worldwide, which makes us the largest of the offshore firms. We have 10 offices globally, covering 6 jurisdictions. For the purpose of today's presentation, the key jurisdiction that we see being deployed by asset managers in Japan is the Cayman Islands. We've been operating in Hong Kong since 2003, Singapore since 2009. The major part of our business focus is on the Japan market, working specifically with asset managers based in Japan and also with foreign managers looking to raise capital in Japan. 64 lawyers in Asia, 26 specializing in fund formation. In terms of our offices, visually showing where we are, Hong Kong and Singapore is relevant to the Japan market. We don't practice Hong Kong and Singapore law. We only practice, for the purpose of this, Cayman Island law out of those 2 jurisdictions. Tim, over to you, please.
Thanks a lot, Tom, and good evening, everyone. We're very privileged to have the opportunity to present to you this evening. So the next part of the presentation is looking at why Japanese asset managers would choose to structure an alternative investment fund in the Cayman Islands. And the first and arguably most important reason is that the Cayman Islands is a popular jurisdiction within the Japanese funds industry. And we consider there to be three main reasons for this. The first is familiarity to Japanese investors. Cayman has long been a familiar and popular destination of Japanese investments in financial securities, and it has grown in popularity with recent reports noting that investment in securities in the Cayman Islands are at an all-time high for Japanese investors. This means that using a Cayman fund structure will enable Japan-based asset managers to focus on raising capital without the additional challenge of getting Japanese investors comfortable with a less familiar fund domicile. The second reason is favorable Japanese tax treatment. It's important to disclaim here that myself, nor Tom, nor Walker's as an offshore law firm is qualified to advise on Japanese tax law. However, we work closely with the tax advisors in Japan and are aware that there are potential Japanese tax benefits when using a Cayman fund structure, and we'll consider this further a little bit later in the presentation. Third main reason is relevant to the Japanese regulatory regime. As you will know, marketing and selling securities and providing investment advice is heavily regulated in Japan. Having worked closely with Japanese counsel over many years, we understand that using a Cayman fund structure can result in securities being offered in Japan without the need for the full license that is required for the domestic structures. Again, we'll consider this a little bit further later in the presentation when comparing the different types of fund structures available. So more generally, the Cayman Islands is recognized as an established international financial center, and there are a number of reasons for this. The Cayman Islands as a jurisdiction offers a politically stable and neutral venue to conduct international business, whether it is launching a fund or structuring a cross-border M&A or finance transaction. The Cayman Islands also provides a tax-neutral platform. There will be no taxes payable at the Cayman Islands level, so no tax leakage at the level of the fund. The Cayman Islands also has a very trusted and reliable legal system. Cayman Islands law is derived from English common law, and this ensures that Cayman Island entities, including fund vehicles, are internationally understood and accepted by investors. The Cayman Islands court system is well developed, with appeals going to the Privy Council in London. The Cayman Islands has long been committed to implementing best international practices and is compliant with the anti-money laundering and anti-terrorist financing requirements of the OECD and the Financial Action Task Force. The Cayman Islands has also entered into a multitude of tax information exchange agreements and was an early adopter of FATCA and CRS, which we'll look at a little bit later. Another key advantage of setting up a fund in Cayman is that the jurisdiction has progressive, innovative, and business-friendly legislation, which is developed and regularly updated in consultation and collaboration with industry stakeholders. Finally, and another important consideration, speed. You can set up a fund in the Cayman Islands very quickly. Once all the necessary information, including KYC documentation, has been provided, all types of investment funds can be established and then registered very quickly. which is helpful if you're trying to get to market on a short timeline. So with that, I'll hand over to Tom for the next part of the presentation.
Thank you. In terms of the next part, overview of structure types and key differences, there are several different types of structures that are available in Cayman that would be relevant for asset managers in Tokyo and globally. So the purpose of this next section is to very quickly go through the key differences and what would be relevant for the particular type of structure. Stepping back, in terms of the work that we do in Tokyo, the asset managers can broadly be divided into two types of strategies: open-ended funds and closed-ended funds. Now, it's key to distinguish between an open-ended fund and a closed-ended fund, because ultimately that will affect the legislative regime in the Cayman Islands that the fund will ultimately be subject to, whether it be the mutual funds regime or the private funds regime. We'll discuss the differences later, but it's key to establish whether a fund is open-ended and closed-ended so that we know which regime will be relevant to a fund being set up by an asset manager. Now, an open-ended fund, the key distinguishing feature is the right for an investor to withdraw or redeem their interest voluntarily at their discretion. If an investor does have the right to redeem or withdraw, then usually that will be a key distinguishing feature for an open-ended fund. A closed-ended fund is the opposite, as you'd expect. That's where investors do not have the voluntary right to redeem or withdraw at their discretion. Now, the reason for having a fund open or closed-ended relates to the liquidity of the underlying investments that the fund is investing into. For example, a hedge fund or a mutual fund will generally invest into a very liquid asset base, such as listed equities, bonds, ETFs. The manager will be able to crystallize an underlying portion of those investments to satisfy a redemption or a withdrawal request. And so usually they are open-ended. Conversely, a private equity fund, a venture capital fund, a real estate, an infrastructure fund, the nature of their underlying investments is usually illiquid. For example, unlisted securities, a building, a highway. And so in that particular case, investors do not have the right to withdraw or redeem at their option, because those redemption requests ultimately cannot be met by the illiquid nature of the underlying securities. As you would expect, depending on whether it's an open-ended or closed-ended, really does impact the type of legislative and regulatory oversight that the regulator in Cayman will ultimately have in relation to those structures. So the first key consideration for asset managers to ascertain is whether they intend to have an open-ended or a closed-ended structure, as that will impact the regulatory world and regime which it falls into. As far as structuring choices are concerned, and we will go into a lot more detail, but just to present the main options up front, Cayman as a jurisdiction, it's, as Tim said, it's common law based, and so we do have the usual common law vehicles that you would expect: unit trusts, exempted limited partnerships, exempted companies, and LLCs. Unit trusts are analogous to the Japanese Toshi Shintaku type structure. It's a very familiar concept for managers and investors in Japan. It's not a legal entity. The trustee will hold all the assets. The ELP, the partnership, is obviously a partnership, so it's not a legal entity. The GP will take all actions on behalf of the fund. Exempted companies and limited liability companies are legal entities. We present them so there is a full picture of the available options of vehicles, but we really do not see them being deployed in Japan for a variety of tax and regulatory reasons. The key consideration here is that there is not one size fits all. Each of these structures are extremely different. Managers very much need to work with their legal advisors and work with their tax advisors to ascertain as to which of those structures is most appropriate for the type of fund that they're looking to do. It also depends on the strategy. To the extent that it's an open-ended hedge or mutual fund, then in all likelihood, it'll probably fall onto a unit trust. To the extent that it's an exempted, a closed-ended structure, then we do see asset managers in Japan falling more into the ELP bucket. But it very much depends on all of those factors, and ultimately, a variety of those factors will ultimately influence the choice of what type of structure. All of these are available, but again, we do see asset managers in Japan gravitating to the first two, depending on their strategy and their appetite from their investors. Tim, unit trusts.
Thanks a lot, Tom. So yeah, we're now going to spend a bit of time talking through the two most common fund structures that we see being used by Japanese asset managers, and in turn, used by Japanese investors. And the first structure that we're going to look at is the Cayman Islands unit trusts, and we've called this the tried and tested structure because it is very much well established for the Japanese market, in particular when it comes to structuring hedge funds for Japanese investors. And what I'm going to do is first look at what a Cayman Islands unit trust is, and then also look at the pros and cons for using it in the context of the Japanese market. So in terms of what is a unit trust, well, as the name implies, it's a type of trust. Cayman Islands trust law is based on English trust law, and this means that the trust itself has no legal personality. Rather, it is a creature of equity, and it is the legal relationship where a trustee holds the legal title to the assets for the benefit of others. The trust is established by a declaration of trust or a deed of trust, and this will be the constitutive document for the unit trust. And by comparison with other fund structures, if you have a Cayman Islands partnership, then the constitutive document would be the limited partnership agreement. And if you had a Cayman Islands company, then its constitutive document would be the memorandum and articles of association. For the unit trusts, the trust will be operated by a trustee, and the powers, duties, and discretions of the trustee will be set out in the trust deed. The trust deed will frame what the trustee can and can't do. All of the assets of the trust will be vested in the trustee under the terms of the trust deed. And then the unit holders are issued units in the trust. So of relevance to this presentation, a unit trust is also a type of fund, and Tom has already set out the different types of fund vehicles available in the Cayman Islands. So where the unit trust is the fund vehicle, then its unit holders will be the investors. The trustee would then delegate the management of the fund to the Japan-based investment manager, who will make the investment decisions on behalf of the fund. And then this last point, which again we've kind of mentioned, a Cayman Island unit trust is very well established and tried and tested in the context of open-ended hedge funds, although it is possible to structure unit trusts for closed-ended fund structures, and we have assisted clients with setting up those structures where the Japanese investors really want to use a unit trust in the context of a closed-ended fund. But it is much more common to see the unit trust being used as an open-ended hedge fund. So here we just have a very simple structure chart showing the unit trust fund structure. So you can see the unit trust in the middle of the diagram. So that is the fund. It will issue units to the unit holders who are the investors. The unit trust will be established by the trustee, who will hold the legal title to the fund assets pursuant to the trust deed. There will be an offering document, and we'll talk about offering documents a little bit later, but they will set out the terms and conditions to potential investors who want to invest in the fund. And then the trustee will delegate the investment management function to the Japanese-based asset manager pursuant to the management agreement. And that management agreement will set out the authority that the manager, the scope of the authority that the manager has to manage the fund assets. And in the context of a hedge fund, the manager will normally have, broad discretionary management authority to manage those fund assets on behalf of the trustee who is acting as the trustee of the unit trust.
Just, Tim, if I could add something on this particular slide. The nature of a unit trust, particularly being deployed in the Japan market, and the reason why it's tried and tested is that this is a very safe, if that word can be used, fund structure. The fact that the operator of the fund is the trustee, which will usually be a licensed independent operator based in the Cayman Islands. It may be based in other places, but usually for the Japan market, we do see independent regulated trust companies in the Cayman Islands acting as trustee. They are ultimately responsible. They have fiduciary responsibilities to the unit holders and the investors. The manager derives its power through the management agreement as an agent of the trustee, as a delegate of the trustee. So at least as a matter of Cayman Islands law, there are no fiduciary obligations directly to the unit holders by virtue of the trust structure. So from a matter of Cayman Islands law, I understand Japan law might make a slight difference to that, but as a matter of Cayman Islands law, the fiduciary obligations in relation to the investors are on the trustee in favor of the unit holders, not from the manager. So in this manner, it's a safe structure in that the manager is somewhat ring-fenced from having privity of contract to and exposure to the investors of the fund structure.
Thanks a lot, Tom. Great point, and also leads us nicely on to the next slide, which is just looking at the pros and cons of the unit trust structure for the Japanese market. So looking at the pros, and some of this ties back to the earlier slide, and also what Tom has just been talking about. Can't emphasize the importance of having a familiar fund structure when a manager is perhaps raising its first offshore fund. As we've said before, the Cayman Island Unit Trust is similar in nature to its domestic counterpart, the Japanese Investment Trust. And this, means that Japanese investors are often more familiar with this fund structure, even if they've not invested offshore before, rather than, say, a fund structured through a company or a partnership. And this has meant that over time, it's resulted in the Cayman Island Unit Trust being this tried and tested structure for successful Japanese offerings. From a tax perspective, there are potential Japanese tax benefits where the fund is structured as a trust rather than as a corporate vehicle. In particular, we understand from Japanese tax advisors that there are possible exemptions under the Japan anti-tax haven law that may be available to unit holders in an offshore unit trust that would not be available to shareholders in an offshore company. And we understand that this effectively will put Japanese investors holding units in an offshore trust in the same tax position as if they had held an interest in a domestic investment trust. Regulation, and again touched on this earlier, our understanding is that by using an offshore unit trust, the securities can be offered in Japan without the need for the full regulatory license that is required for the domestic, for a domestic structure. And this makes the unit trust a very effective and efficient structure for managers, for both the managers and for the Japanese investors that invest in their funds. And then this final point, which Tom had just kind of picked up on, Japanese investors, may well take comfort that there is a professional trustee engaged who is responsible for the fund's assets and is under a fiduciary duty to its unit holders, to the investors. And in this regard, the trustee can be viewed as a check and a balance to the manager. So yeah, and now looking briefly at the cons, the nature of a trust means that it is less flexible than a partnership. And Tom will look at the flexibility that a partnership offers shortly. And the underlying legislation, the trust law, is indeed less flexible than the partnership law. And kind of linked to that, when investors subscribe for units, they will invest their monies and are issued those units on day one, and there isn't the capital commitment, capital call mechanism that you get under a partnership that works so well for closed-ended funds. It is possible to kind of build that mechanism into the documents, but it does always require the issuance of units, and it's just not quite as flexible as the partnership structure. And so just to then go to the kind of last bullet point, that's really why, one of the main reasons why unit trusts are not seen not seen that often for closed-ended funds, but are very, very common in the tried and tested structure for hedge funds. Tom, I'm not sure if you have anything else to add on the unit trusts. Otherwise, I'll hand over to you to talk about the partnerships.
Moving on, we want to look next at the ELP, so the exempted limited partnerships. This is the classic structure that we see in not just the Japan market, but globally when it comes to closed-ended funds, such as private equity, such as real estate, infrastructure funds. As I said, this isn't just a Japan quirk; it is very much a global trend that we see. We have, in the past couple of years, seen a bit of a growing trend using exempted limited partnerships for open-ended real estate funds, but for the most part, this is the classic structure for closed-ended funds in Japan. As the name implies, an ELP is a special type of a partnership. Under Cayman Islands law, the partnership must be a business carried on by 2 or more persons in common, acting with a view to profit. At its inception, a partnership requires at least 1 general partner. This general partner is usually a Cayman exempted company, but it can also be a foreign company. We have set up many ELPs with KKs, Kabushiki Keishas, as the general partner, provided that they're registered in Cayman, but there must be at least 1 GP and 1 limited partner. The relevant laws when it comes to setting up an ELP in Cayman is the exempted limited partnership law. This was fairly recently updated, and it does provide a wide degree of flexibility for the partners to regulate the terms and conditions of the actual partnership. As Tim alluded to earlier, the limited partnership agreement is the key constitutional document that governs the ELP. It sets out all of the commercial terms, it sets out all the respective rights as between the general partner and the limited partners. Like a unit trust, it's a flow-through entity. It doesn't have a separate legal personality, and therefore it cannot actually hold assets in its own name. It cannot sue and be sued in its own name. It must be through the general partner. The assets are held, as I said, by the general partner on a statutory trust for the partnership, and the general partner will always enter into documents for and on behalf of the partnership itself. Next slide. As we've said, the ELP is the most favoured structure for private equity funds. The partnership is the fund vehicle, and the general partner will conduct the business on behalf of the fund. The GP will then usually delegate all or part of the actual management function to the investment manager pursuant to an investment management agreement. So it's very similar in terms of structure to the earlier slide for unit trusts. One of the key features and the reason why this structure is so popular globally for these types of funds is that the limited partners, the investors in the fund, will have limited liability on the proviso that they do not take part in the business or the conduct of the partnership. Structurally, the investors, the limited partners, will make capital commitments to the fund, and the general partner will call down the capital as and when the fund needs its investment. That is a key distinguishing feature from an exempted limited partnership. It's why it's so popular in the context of a PE fund or an infrastructure fund, where the manager will identify certain investments, and upon identifying that investment, the GP on behalf of the GP for and on behalf of the manager will draw down commitment from the actual LPs that will ultimately fund that project. So it works extremely well structurally for a closed-ended type of fund structure. The LPs hold an interest in the partnership in respect of the profit, capital, voting, and any other rights which are commercially set out in the limited partnership agreement. Looking at what that structure looks like in practice, you'll see on this particular diagram here, we've got the ELP in the center of the chart. There will be the general partner off to the right there, which will hold the assets. It will basically be responsible for the business and the affairs of the partnership. To the right, there will be a management agreement where there'll be a further delegation of the management function. The day-to-day functioning of the partnership of the fund will ultimately be delegated down to the investment manager. Looking upwards, the limited partners will hold interests in the ELP. On the left there will be a limited partnership agreement, which will be the key constitutional document, which will govern the relationship as between the LP and the GP. A PPM, we'll get into this later, whether the fund actually has an offering document, some marketing material that sets out a lot of the commercial terms, a lot of the background is usually optional in the context of a closed-ended fund structure. For the most part, for some of the larger closed-ended funds that we do in Japan and in Asia, it's probably about 50% of the time we'll see an offering document. The other 50% of the time, we generally won't see offering documents. The investors will simply look to the limited partnership agreement and or a side letter that they'll negotiate with the general partner and the manager. And in that case, we wouldn't generally see an offering document. It is optional in a closed-ended structure. In an open-ended structure, it's not optional, it's mandatory. Moving on in terms of pros and cons, and I am aware that we've only got another 10 or 12 minutes to go, so I will jolt through these fairly quickly. The advantages of an ELP in the Japan market is that it really is a classic, dare I say, tried and tested structure when it comes to closed-ended private equity funds. The latest numbers are about 20,000 ELPs globally. So these are a really popular structure that has been deployed globally as far as this type of strategy is concerned. In Japan, they are used. There's a widespread prevalence of usage in Japan as well. The capital commitments and calls is one of the intrinsic features of an ELP structure, and it is so integral to a PE structure where there are commitments and the GP will call for capital as and when investments are required. The fact that partnerships have this feature innate in its structure means that it works extremely well. There's very flexible law in Cayman Islands when it comes to partnerships. The ELP legislation intentionally allows for the parties to contractually agree almost most issues as amongst themselves, and so it is extremely flexible, whereas with unit trusts it's more constrained by concept of trustee fiduciary duties and maintenance of capital and those types of concepts. So there's a lot more flexibility. It is possible to unitize the partnership interests, which means that the structure can also be used in open-ended structures where NAVs are required. So again, it just goes to that additional flexibility that ELPs have. The Article 63 exemption, at risk of overstepping the mark and talking about Japanese regulation, which we're not qualified to do. We have, however, managers in Japan have been able to rely on the Article 63 exemption in order to distribute offshore partnership interests in Japan. So it is available. It can be distributed in Japan going through those exemption channels. On the disadvantages, again, the Article 63 exemption is more complicated these days, requiring a Japan representative. So there is some regulatory hurdles to go through. So that is considered by some managers to be somewhat of a disadvantage. No legal personality. It is what it is somewhat. The fact that all actions and business must go through the general partner can be seen as burdensome by some managers, although ultimately the responsibility does get delegated to the manager. But the fact that there is no legal personality is sometimes seen as a disadvantage. And finally, the GP and the fiduciary duties. It's an interesting point, this one. The law in Cayman does require that the GP act in good faith at all times, but it is able to commercially agree in the LPA to vary certain fiduciary duties. Often it does, for example, enable the GP to take into account certain other interests, for example, LP interests. At times, this might not be might not be of appeal to institutional investors who like to see that fiduciary duty as a bit of a check and balance on the otherwise wide range of power that the GP can otherwise exercise. Apologies for going through it rather quickly, but we should move on to the regulatory regime. Thanks, Tim.
Yeah, thanks a lot, Tom. And I'm conscious we only have 5 or 7 minutes left, but it would be worth just briefly spending this remaining time just to touch on the Cayman regulatory regimes, which will be important for Japanese asset manager to be aware of and to navigate, noting that these regimes are relevant to the fund itself and not directly to the manager. So I think the most important point to talk about with regards to regulation is that both open-ended and closed-ended funds will be required to register with the Cayman Islands Monetary Authority, which is the regulatory body in the Cayman Islands, I guess, by comparison to the FSA in Japan. If it is an open-ended fund, then it will need to register pursuant to the Mutual Funds Act. And this registration requirement has been around for many, many years. If it is a closed-ended private equity or venture capital fund, then it will need to register pursuant to the Private Funds Act, which is a relatively new requirement for closed-ended funds that was introduced in 2020. In general terms, the Cayman Islands Monetary Authority operates a fairly light touch disclosure-based regime, and it is important to note that except for certain types of special funds which are beyond the scope of this presentation, it is a registration requirement and not an approval requirement, meaning that the Cayman Islands Monetary Authority does not need to give its prior approval to register the fund and allow it to launch. Rather, the registration will effectively be automatic so long as all of the conditions to registration have been complied with. So turning briefly to the registration requirements themselves, on the left-hand side, we have the requirements for an open-ended fund structure. So the application will be made by way of completing a registration form, which will be submitted online and will contain various key information about the fund, its service providers, key terms, and will require certain documents to be uploaded and filed with CIMA as part of the registration application process. And the key document for a mutual fund will be the fund's PPM or its offering memorandum. And as Tom mentioned, it's a legal requirement for an open-ended hedge fund to have a PPM and to maintain that. And so it will be filed with CIMA at the time the fund is launched. And to the extent there are changes to the terms of the PPM or to the fund generally, then there'll be a subsequent obligation to notify CIMA of those changes within 21 days. CIMA has provided a list, really, a kind of contents list of the key information that needs to go into the PPM. And so it'll be important that your Cayman Island Council checks off everything on that list to make sure everything is in the PPM that is required by CIMA to be in there. A couple of important points to note for a mutual fund: it must have a Cayman-based auditor who will sign off on the fund's audited accounts and will file those accounts with CIMA within 6 months of the end of each financial year of the fund. This type of fund will also need to have an administrator. That administrator doesn't need to be based in the Cayman Islands, but it is a requirement to appoint an administrator. There will be an annual fee that is payable in order to be registered, and that fee is around $4,000 US. So briefly, just comparing the requirements of an open-ended fund with a closed-ended fund. Some things are similar in terms of the registration application, the need to appoint a Cayman-based auditor who's going to file those accounts, the need to pay an annual fee. I think probably the key distinction to note, which Tom has already kind of mentioned, is for a closed-ended fund, there is no requirement to have an offering document or a PPM, and therefore there is no requirement to file one as part of the registration application. There are ongoing obligations for both types of funds, actually, and how the fund complies with those obligations will need to be summarized in the application. So just now, kind of very briefly, there are ancillary regulatory regimes which will be relevant to the fund, and the two that we're going to look at apply equally to open-ended funds and to closed-ended funds. And those regimes are the Cayman AML regime and the Cayman FATCA CRS regime. So I won't go into detail in terms of the legislation itself, but broadly speaking, the Cayman AML regime is centered around the prevention and detection of money laundering, terrorist financing, and proliferation financing. And it's comprised of two parts: AML procedures and AML internal controls. And the combination of the procedures and the internal controls, sets out a framework to ensure that the fund has the right policies and procedures in place to make sure that that the AML requirements are satisfied. And I think really the most important takeaway here for Japanese asset managers is that there are specialist service providers that will be able to perform AML compliance on behalf of the fund. And it doesn't matter whether it is a unit trust or a partnership structure. There's a lot of very experienced service providers that will help the fund comply with these regulatory requirements, and the manager itself will not need to be too involved in the performance of the compliance functions. So just very briefly, I'll hand over to Tom to touch on FATCA and CRS.
Thanks, Tim. The final slide that we're touching upon is just the AEOI regime, so FATCA and common reporting standards. Just to finish off on this note by saying none of this should be a surprise for asset managers in Japan. Japan is the signatory to common reporting standards. Cayman funds are financial institutions, and so are therefore also subject to the usual obligations as far as registration and reporting and ongoing compliance policies and procedures with FATCA and CRS. Pointing this out as that this is a very important obligation for open and closed-ended funds for asset managers in Japan looking to use Cayman structures. On that note, that brings an end to our presentation. We appreciate that there was a lot to get through. We are very grateful to FinCity Tokyo for inviting us to speak tonight. If there are any follow-up questions in due course, please feel free to reach out to Tim and myself. Our details are on the Walker's website. But thank you again, and we hope you have a good evening. Thank you.
Thank you very much.
Granger-san, Stevens-san, thank you very much for your presentation tonight. 以上をもちまして